Yes, good morning and welcome back. This is Citizen Extra, the Ballot 2017 edition, where we continue our special coverage of the 2017 general election, and now more specifically, the repeat presidential election that we expect to take place next month. My name is Freddy Ndimuli, in studio with my panelists, Didmas Barasa and Piki Milili, George Wajakoya, political analyst, Ken Ambani, and Dr. Kabare Karanja, also political analyst. Our main point of discussion today is this petition filed by Nyeri Town MP Ngonjiri Wambogo seeking the removal from office of Chief Justice David Maraga. Who exactly does it benefit? For example, does it even stand to benefit the MP himself? Let's go straight to his constituency, Nyeri Town. Reporter Martin Munene is there and will sample some of the views from residents of Nyeri Town with regard to this petition filed by their MP to the Judicial Service Commission. A very good morning to you, Martin. What are the people of Nyeri saying about what their MP is up to?
A very good morning to you, Indimuli. And indeed, like you're saying, you are getting us live from Nyeri County, specifically in Wadera constituency, where the state lodge is located, where President Kenyatta is meeting Mount Kenya region leaders. And with me here today is the Madera legislator, the Honorable Rigathi Gachagua, who's going to be giving us a perspective on that particular issue concerning what happened yesterday. The Nyeri Town MP Ngonjiri Wambogo moved a petition for the removal of the Chief Justice David Maraga, and we're trying to find out what the residents of this county feel about that particular move. Yesterday we talked to some residents, and actually the opinions are actually varied as the number of people. Some feeling that it represents their interests, others feeling that it does not represent their interest. It is a personal move. And so kindly, Mheshimiwa, if you can join me here, help us understand the move by the Honorable Ngonjiri Wambogo. Is it a personal move, or does it?
We'll give it a few minutes because even as we have that poor signal, we really want to get some of those reactions from that particular county. That's the county of Nyeri, where the MP for Nyeri Town, Ngonjiri Wambogo, is from. Let's listen in. We do understand we have a stable signal now. Unfortunately,
they had every right to challenge these elections, much as we were unhappy that they were doing so. The Honorable MP for Nyeri Town also has a right, where he feels that the Chief Justice has misconducted himself. He has a right to seek legal redress so that the Judicial Service Commission can look into it, and if there is merit, the Chief Justice is sent home. If there is no merit,
yes, that's a member of the National Assembly representing Matera constituency, Rigathi Gachagua, giving his reactions to that petition filed by his colleague, Nyeri Town MP, Ngonjiri Wambogo, seeking to remove CJ David Maraga from office. We do apologize for that poor signal. Of course, we'll try and get more reactions from that particular area, although MP Rigathi Gachagua there supporting his colleague and saying he has all the right to go to the Supreme Court. I promised to take a look at the Constitution, Chapter 10 of the Constitution of Kenya. This is a chapter on the judiciary, Article 168, on the removal from office of a judge of a superior court. And it says a judge of a superior court may be removed from office only on the grounds of A, inability to perform the functions of office arising from mental or physical incapacity, B, a breach of a code of conduct prescribed for judges of the superior courts by an act of parliament, C, bankruptcy, D, incompetence, or E, gross misconduct or misbehavior. Those are the grounds for removal of a chief justice, of a judge of a superior court, and that includes the chief justice. Now, the removal of a judge may be initiated only by the Judicial Service Commission acting on its own motion, or on the petition of any person to the Judicial Service Commission, which is the case right now. This motion has been filed by a person to the Judicial Service Commission. Now, the petition by a person to the Judicial Service Commission under Clause 2, which I've just read, shall be in writing, setting out the alleged facts constituting the grounds for the judge's removal. The JSC shall consider the petition, and if it is satisfied that the petition discloses a ground for removal, it will send the petition to the President. Then the President shall, within 14 days after receiving the petition, suspend the judge from office and, acting in accordance with the recommendation of the Judicial Service Commission, appoint a tribunal in the case of the Chief Justice, which consists of Speaker of the National Assembly as a chairperson, 3 Superior Court judges from common law jurisdiction, 1 advocate of 15 years standing, and 2 other persons with experience in public affairs. Now, this is a constitution of Kenya as it is, and this is following this particular petition filed before the Judicial Service Commission. This is a route it has to take. That yes, the Judicial Service Commission has to look at the grounds presented in the petition. If they're satisfied, then present that petition to the President, who will then have to form a tribunal. Yes, within 14 days. Yes, this is very interesting because yes, now we're looking at the reality that yes, if at all the grounds are satisfactory. But even before, without even trying to be prejudicial, the grounds that you're looking at for the removal of the Chief Justice, do you think any of those grounds that Ngujiri Wambugu can actually prove any of these grounds? Forget about incompetence, bankruptcy, because those ones do not really apply in this particular case. Probably the issue of also mental or physical incapacity does not apply this. So the grounds, there are 2 grounds here I'm saying: a breach of a code of conduct prescribed for judges of the superior courts by an act of parliament, or gross misconduct or misbehavior. Those 2. And I should believe that is what the petition is based on. Do you think that is something easy to prove of the Chief Justice at this point in time, Dr. Kabare?
Very well, Fred. I think I would not want to speculate as to the content of the Ngujiri's petition. And I also agree with what we've just heard. Yes, he has, let's begin there, he has a right to initiate this petition. The question is, the steps that we have to take, including convincing the JSC that ABCD has happened, and then this matter is referred back to the President. Remember, even before we go to the content, recall that during the state opening of Parliament, these justices were missing in action. What does that tell you? We were told there was communication to the registrar and so forth, which I think is something very, very, very simple to inviting these judges to come to Parliament. The fact that we didn't see them in Parliament, what does that tell us? It tells us something. Now, when you initiate this process against the Chief Justice, how would you expect the President to deal with such a petition sent to him by the JSC? Then contextualize that with the political climate and temperatures in which we are, where we are still in a political competition. And we are getting to elections in August 17. What would this petition do? I see it poisoning the mind of Kenyans, regardless of the content. I see this being, I see this taking us in the wrong direction.
Did not Barasa, of course, as when Dr. Kabare Karanja says, already the minds of Kenyans are poisoned. In as far as that we extend our political contests well beyond even the election day. For the next 6 months or so, even after the president, we get a new president who's sworn in, we'll still be discussing politics. We'll still be politically charged, speaking from both extremes, either for or against one side or the other. Do you think this is the right frame of mind for a country to actually look to institute changes even in the judiciary? Looking at even the tribunal to be formed, yes, it has to be chaired by the Speaker of the National Assembly. Yes, the tribunal itself will be formed by who? The President, who is already aggrieved by this same court. Do you think this is the right environment to actually institute a proper, sober and clean reform within a judiciary that we say needs some changes? Don't you think that probably it would have been better to wait until everything has calmed down politically, then anything can actually be discussed with a sober mind?
Yes, I agree with you that the timing is wrong. However, in terms of whether there are serious grounds to petition the removal of the Chief Justice, I think this is well known to him. But from the look at the petition where he's saying that the Chief Justice barred another judge from participating in the verdict, where he's saying that certain NGOs have been like making contact with the CJ with a view of subverting justice. I think if he has evidence, these are enough grounds. And I think JSC in itself, it can even before making that recommendation to the president for formation of the tribunal, they must call for other evidence to be able to come up with a more concrete decision as to whether to put forward or to dismiss it. And I think when you are administering justice, you look at quite a number of things. You look at the interest of the country, you look at both the legal framework and the administrative processes. And to me, I think it's not the right time to take Kenya again through these kind of things. We can easily get a constitutional crisis. Even like, for example, some people are calling for the arrest of IEBC officers. Once they begin to be arrested and investigated, I think they will not be improper to oversee the presidential re-election that is coming on the 17th of October. So the timing is completely not right. We need Kenya as a country need to come together. It needs to heal. We need to move forward. We need to move forward away from politics so that we can begin to put Kenya back on the development lane from the political lane.
But we've already started the process. The petition has already been filed. I don't see us going back on it. The Judicial Service Commission and its systems have to kick off and have to go through this because the timings have been prescribed. The Judicial Service Commission cannot decide to wait until after the elections. They have to kick off immediately and address this petition. How much can it affect the conduct of the coming presidential polls? Remember, the Supreme Court is also a major player in this. It could be called upon to adjudicate on this fresh polls once again, once we actually get through the process. If at all the CJ by then is under review by the Judicial Service Commission, what does it mean, Professor Wajakoya?
I think this is a season which I should come up and say very clearly that the judiciary is on trial. And members of the judiciary, wherever they are, lawyers, politicians, academics and non-academics, those who would look at the whole framework will see that there is an impediment of natural law. When you look at their Hammurabian theories of law, they say an eye for an eye. In this context, the president has set the motion by condemning the judiciary, so is his deputy. So whatever comes down thereafter is not really going to be looked into or taken into with a pinch of salt. Because if you get a head of state himself spearheading the war against judiciary, what else do you expect? He is the custodian, as I said before, of the national emblem of this country. Everybody below him, especially when it comes to in terms of appointment of those committees to discipline judges, he is the appointing authority under the Constitution.
He's also the one required to suspend this.
And is only also mandated by the Constitution to suspend. What do you expect? That means that the country is on trial and judiciary is on trial. Secondly, and more importantly, there are petitions that are pending. Given the fact that the NAS are crowing foul of generated voting system, where they are saying or alleging that most of the people who have voted were voted through the computer. Now, if members of the judiciary are being pre-warned in advance by having their own head to be chopped off, the Chief Justice, that means there is an element of fear being inserted in the judiciary. And that's true for a fact. Now, this myopia of saying that we should forget and move on without looking at the decision of the Supreme Court in this country and what it said, that means we are preempting the decision and therefore going ahead with whatever it is. And from what I've learned from my friend here, the Member of Parliament, is that Ngujiri was actually pro-NASA before. That's number one. Number two, he worked within the NGOs. And number three, he has himself said that the Chief Justice actually forced Justice Ibrahim off the track. Justice Ibrahim was actually sick. Therefore, the standard to be applied here is wanting. What if there's a negation of that statement by the Judge Ibrahim himself? If he comes up and said, hey, I was not forced out. I was sick. And this is medical evidence.
Okay.
What about the information he had 4 years ago that he has been lying on? Why couldn't he bring this information before the anti-corruption?
I'll ask you to hold it there briefly. We do understand the government spokesman, Eric Kirai, is currently making an address to the media from Mombasa. Let's listen in to what he has to say.